Good morning, good afternoon, good evening to all of you around the globe who are attending today's webinar. This is the 11th webinar in our series launched in April 2020 by the World Commission on Environmental Law of the International Union for Conservation of Nature. Welcome and aloha from my home in Hawaii, which is on the other side of the globe from our distinguished speakers today in Africa. My name is Denise Antolini. I am a professor of law at the University of Hawaii, William S. Richardson School of Law, and I'm honored to serve today as the Deputy Chair of WCEL and your host. On behalf of the World Commission on Environmental Law, I want to express our gratitude to the speakers, the co-hosts, the organizers, and all the participants who have joined us today for this webinar, Recent Developments in the Environmental Rule of Law in Africa. This is the first of 3 webinars that WCEL is focusing on Africa in the coming weeks. We will send you more information about those future webinars to everyone registered today, and you will see it on our website. I will introduce you in just a minute to the World Commission on Environmental Law, and then turn you over to my colleague, the World Commission on Environmental Law Chair, Justice Antonio Benjamin, who will introduce you to the Global Judicial Institute on the Environment. Then you will hear from Justice Emmanuel Ujiro-Shibuya, the President of the East African Court of Justice, our dear friend and colleague and internationally recognized jurist who is our moderator for today's session. We are very honored today to be joined by 4 other distinguished jurists from Tanzania, Ghana, South Africa, Kenya, and Mozambique, all of whom are outstanding leaders in their courts, regions, and across diverse Africa in areas of judicial developments and judicial education. The World Commission on Environmental Law, or WCEL, is one of the 6 expert volunteer commissions of the International Union for Conservation of Nature. WCEL is a volunteer network of environmental law and policy experts from all regions of the world who volunteer their knowledge and services to IUCN activities and other partners. We have over 1,300 members, many of whom are attending today's webinar, which has over 220 participants registered from all around the world. So please go to our website for more news, information, and updates on our webinar and environmental law lecture series and other resources. As I mentioned, Justice Benjamin will introduce the Global Judicial Institute on the Environment, and we also want to acknowledge today our other partner, the United Nations Environment Program. With GJIE and UNEP and other partners, the World Commission on Environmental Law had been planning our 2nd World Environmental Law Congress for last March 2020 in Rio de Janeiro, Brazil. Unfortunately, due to the global COVID pandemic, like many other organizations around the world, and like the International Union for the Conservation of Nature, we had to postpone our Congress to a future date to be determined. However, even though in-person congresses are not possible right now, our global conservation community and the entire field of environmental law cannot stop addressing the multiple local, national, and international crises that continue to face us. So this webinar series was created to keep the momentum going toward a better world, to engage you, our members, partners, and colleagues around the globe in urgent environmental law conversations, to share the amazing expertise among our members and partners, and to continue to press forward toward a just transformation of conservation law and policy. Today's topics like today's webinar and the other upcoming webinars that will focus on Africa help us keep hope alive for a rule of law and a better world. So now let me explain a few housekeeping functions before I turn it over to my colleague, Justice Benjamin. For those of you who are participating in the webinar today, I'm going to point out some features that will make it more engaging for you. So first, if you can look at the bottom of your screen now and keep an eye on what's called the chat box. So we'll be posting information there we already have. with links and various resources from today's webinar. So we will use that chat box to communicate to you periodically today. Then you will also see the Q&A box. You can open that now, and anytime during the webinar, you can communicate with us. You can alert us about technical issues that we can try to solve while we're in the webinar, but most importantly, we want your questions. So at any time during the webinar, you can type your question in the Q&A box. We will then be consolidating the questions and they will be managed by our moderator, Justice Ujiro Shibuya, at the end of the presentations. A little note on recording. We are recording today's webinar and we are very happy to share that through our website. We will also share the PowerPoint materials with anyone who has registered, and on our website, you will see that all about a week after the webinar. And this information is public. It's meant to be educational. We encourage you to share it. A note about the tremendous effort that goes into the background of these webinars. I want to acknowledge today the assistance of our staff behind the scenes, our friends behind the scenes. Emily Gaskin is our executive officer for the World Commission on Environmental Law. She is an environmental lawyer and she is currently in Seattle. You won't see her today, but she's doing a lot of work to make this all happen and we're very grateful. And from Morocco, Ayman Cherkawi is a member of the World Commission on Environmental Law and an expert in environmental law and climate change. And as I said, he's in Morocco. He'll be helping us manage the questions and the answers. So we thank them both for assisting us today. And we are very privileged to be joined today by 4 excellent professional interpreters, all of whom have expertise in environmental law. Etienne Van Damme and Claude Areau will be interpreting in English and in French. Marilia Rebello and Alice Morea will be interpreting in English and Portuguese. You can choose the language that you wish by going to the bottom of your screen and clicking on the global icon, the globe icon, select the language of your choice. And you can also change the language during the webinar for yourself at any time. If you have any problems that might occur if you hear 2 languages at once, look for the choices there that allow you to mute the original language. So make sure to familiarize yourself with that global language icon. Last, I must add that the views expressed today represent the individual speaker's views and not any official position of IUCN, WCEL, or GJIE. This webinar is purely educational and we hope inspirational. Now, I'm very pleased to introduce you to my dear friend and colleague, Justice Antonio Benjamin, the chair of the World Commission on Environmental Law for the past 8+ years. Justice Benjamin is on the High Court of Brazil, the STJ, and a world-recognized jurist and leader in the field of environmental law. He will now give brief opening remarks and introduce the Institute and Justice Ujiro Shibuya. Thank you. I'm turning it over to you, Antonio.
Thank you, Denise. Muito obrigado. Eu vou falar em português. Não sei se eu tenho que mudar de canal ou posso já falar agora. Do you have interpretation? Yes? Okay. Então, muito bom dia, boa tarde, boa noite. Este é realmente um evento com participação global, embora o foco seja nesse continente extraordinário que nós chamamos de África. Nós sabemos que a África traz em si tudo o que nós temos de biodiversidade no mundo. Das montanhas, às savanas, do litoral aos oceanos, os desertos, florestas tropicais. Enfim, não há ecossistema ou bioma com características que não sejam extremamente locais, que não se encontre na África. Então, não estranha que nós, juízes no âmbito do Instituto Judicial Global do Ambiente, tenhamos a África como uma das prioridades. E eu tenho o prazer, em nome do Instituto, de dar as boas-vindas, em primeiro lugar, aos que nos assistem e depois aos que mais adiante terão a oportunidade de assistir os vídeos desses webinários que são organizados pela Comissão Mundial de Direito Ambiental, com parceria de várias outras instituições. Queria agradecer também a participação desses especialistas extraordinários que se encontram neste painel. Em primeiro lugar, o ministro Justice, Emmanuel Ujirashibuja, que é uma das figuras extraordinárias da magistratura africana e mundial. Ele que é ex-presidente, ou melhor dizendo, é ex-diretor da Faculdade de Direito de Kigali, um centro de estudos jurídicos muito reconhecido na África, fez o seu mestrado e doutorado com foco em direitos humanos e também no meio ambiente, e nos últimos anos vem sendo o presidente da Corte Africana do Leste, the East African Court. É um jurista de mão cheia, admirado por todos, e por isso é um privilégio para o Instituto Judicial Global do Ambiente tê-lo como membro do seu comitê executivo, the Interim Governing Committee, e também contar com a sua experiência, com as suas lições em tudo o que nós fazemos. Mais importante de tudo é o exemplo que ele nos dá do que é ser um bom juiz. Um bom juiz e um grande homem. Então, por isso, a alegria de todos nós contarmos com a presença dele aqui. Mas eu peço que também não percam o simbolismo da diversidade de gênero que nós temos neste painel. E isso é algo muito importante para o Instituto Judicial Global do Ambiente. Nós sabemos que as mulheres, embora sejam maioria em boa parte dos países, ainda são uma minoria, sobretudo nas cortes supremas, nas cortes superiores. E aqui é o bom exemplo que o Instituto dá, porque nós temos entre os 4 palestrantes 3 mulheres. E que 3 mulheres! Cada uma delas representando o que há de melhor, não só no seu país, mas na sua região. Eu começo por aquela de língua portuguesa, minha colega Elisa Samwell, que é diretora da Escola Judicial, da Judicial Academy de Mozambique, que é um centro de excelência de formação judicial no seu país. E eu costumo dizer que, embora Moçambique, até onde eu sei, não tenha vulcões naturais, mas tem, Elisa, um vulcão do bem, um vulcão humano, que derrama energia, alegria, conhecimento, trabalho por onde vai. Por isso, a alegria é muito grande de contar com a sua presença hoje aqui. Em segundo lugar, temos a minha colega, querida amiga Nambita Dambuza, da África do Sul, a ministra Justice, Nambita Dambuza, que é uma dessas figuras que encantam a magistratura, o poder judiciário da África do Sul, mas também da África e do mundo como um todo. Ela é um exemplo do que há de melhor neste poder judiciário dos nossos países, que está em permanente evolução e em permanente progresso. Ela é o exemplo do progresso. Progresso nas ideias, progresso no modo de ser, de encarar os desafios de países todos, como os nossos, que estão em desenvolvimento e têm dificuldades enormes. Contamos ainda com a presença da minha colega ministra Justice, Millicent Denis, que vem deste país extraordinário que é o Quênia. Vários países africanos disputam a posição de coração da África. Mas creio que a Quênia tem condições de dizer que faz parte do coração da África. E faz parte do coração de todos nós que admiramos a África e os grandes avanços que tem feito em direito ambiental. Como ela mesmo indicará em seguida, Quênia foi um dos primeiros países na África a instalar um tribunal ambiental e a criar várias especializadas green benches no âmbito do próprio judiciário. Ela é uma especialista em direito ambiental e certamente vai nos dar aqui lições que serão úteis não só para a África, mas também para todos os países que se juntam nesse esforço hoje. Finalmente, temos como expositor o ministro Sir Denis Adjei, que vem de um país que é muito admirado na África e no mundo todo. E não só pelo famoso Império de Gana, que não era exatamente em Gana, ou só em Gana, e que foi uma das maiores entidades políticas na história da África. E Gana tem dado ao mundo grandes expoentes no direito e também na diplomacia. Basta lembrar o secretário-geral Kofi Annan, um exemplo para todos nós e para as lideranças internacionais. E o Poder Judiciário de Gana tem feito avanços também nesta área ambiental e o nosso colega tem também participado no plano africano desta rede, network, de escolas judiciais. E hoje ele é o presidente desta rede, que conta, inclusive, com a participação da nossa querida juíza Elisa. Bem, vejam que grupo extraordinário de palestrantes que nós temos, e o Instituto Judicial Global do Ambiente se sente muito feliz em participar e ajudar neste evento, na sua organização. Por último, para não perder muito tempo, eu queria agradecer de coração a professora Denise Antolini e a equipe que a cerca, especialmente a nossa querida Emily Gaskin, que é a pessoa por trás de tudo o que nós estamos aqui assistindo. Não sei se os que nos assistem têm noção das zonas de horário, mas a professora Denise Antolini está no Havaí, o que significa dizer que agora são 3h da manhã na bela Honolulu. Isso já demonstra a dedicação desta professora, dessa jurista magnífica que nós temos o prazer de contar ao nosso lado. E contar ao nosso lado em todas as horas, em todos os momentos. Ela é realmente um espírito e uma mente dedicada ao direito ambiental e ao bem de todos, dos humanos e da comunidade da vida no nosso planeta. Como ela disse, nós contamos também com a presença do nosso colega Ayman Cherkaoui, do Marrocos, que vem ajudando, sobretudo nestes eventos na África, as instituições de organização. O Ayman Cherkaoui tem uma larga experiência não só em mudanças climáticas, mas na cooperação internacional e nos fóruns em que essas grandes questões do direito ambiental são discutidas internacionalmente. Com isso, eu queria agradecer mais uma vez, em nome do Instituto, a todas e, em especial, à professora Denise Antolini e ao presidente dessa sessão, o ministro Emanuel Ugirachebuja, a quem eu passo a palavra.
Thank you very much, Justice Antonio Benjamin, for those remarks that you made about me. And I am very glad to be the moderator for this session. And I'm also very happy for having, in a very small measure, contributed to the success of this webinar. The purpose of today's webinar is largely knowledge sharing and deepening a shared understanding of the key aspects of recent developments in the area of environmental rule of law.
Judiciaries can derive from each other such benefits as may be offered to each other in as far as the development of the environmental rule of law is involved. The WCEL, in partnership with UNEP and the African Judicial Academy Network, offers this webinar. The panelists are drawn from highly experienced judges from different African judiciaries, from the north to the south of Africa. And with us today we have 4 distinguished judges. The first judge is Justice Dennis Adjei, who is a professor of law and is a justice of the Court of Appeal of the Republic of Ghana, and currently the Dean of the Faculty of Law of the Ghana Institute of Management and Public Administration. He also serves as the director of the Judicial Training Institute, which provides continuous legal education for the judges in Ghana. Professor Justice Dennis Adjei has many publications to his credit and is an astute jurist and academic with recognized competencies in many fields of law. The second distinguished speaker is Justice Nambitha Dambuza. Justice Dambuza has served as a judge of the Supreme Court of Appeal, South Africa, for the last 6 years. Prior to that, she was a judge of the High Court in the Eastern Cape province for 11 years. Before her elevation to the bench, Nambitha was a practicing attorney in Butterworth and East London, South Africa. She currently serves as the chair of the Rules Board of the Courts of Law and member of the Judicial Conduct Committee of the Judicial Service Commission. She is also a council member of the South African Judicial Education Institute and is the convener of the New Judges Orientation Seminar. She's also a visiting professor at the Rhodes University Faculty of Law, Grahamstown, South Africa. The third distinguished speaker is Lady Justice Dr. Millicent Odeni. Millicent Odeni has served as a judge of the High Court of Kenya since 2016. Before her appointment to the bench, she had more than 24 years of experience in legal practice and international rule of law. She previously worked as a principal lecturer at the Kenya School of Law in the Department of Continuing Professional Development and Research. She also worked as a land lawyer for USAID-funded project in South Sudan and has carried out extensive research on women's land rights. She was the lead consultant for the Land Policy Initiative study on strengthening women's land rights in Africa, which was published in 2013. She is currently based in a very beautiful city in Kenya known as Eldoret at the Environmental Land Court. Then last but not least, we have Judge Elisa Samwell. Judge Samwell currently serves as the director of the Center of Legal and Judicial Training of Mozambique. As director, she is a member of the Advisory Council of the Ministry of Justice, as well as the Executive Secretary of the Mozambican Judges Association. She previously served in various roles in the judiciary of Mozambique as a judge and president of the Judicial District Courts of Belém, Macia, and Machava in Maputo Provincial Court. She's a former member of the Judicial Commission and its Permanent Commission, and she was also part of the commission in charge of to draft the regulation of the appointment of judges. I now call upon Justice Dennis Adjei to make his 15 minutes presentation.
Thank you and good afternoon to my brother Emmanuel for the kind words you've said about myself and my colleagues on this platform. I'm talking on unmasking the perpetrators of environmental crimes in Africa. Why I chose this topic is that we always talk about environmental degradation, environmental crime. We know that crimes have been committed, but why are they not prosecuted? Where are they? We continue to always talk about crimes, and it goes on and on and on. So how do we do away with this question about who are the perpetrators? Environmental matters reign supreme by the fact that human beings, animals, fishes, and plants depend on environment for their survival. A healthy environment produces healthy life for all the living creatures within that environment, while unhealthy environment produces unhealthy creatures. The importance of safeguarding the national environment for the cooperation of other countries and international bodies has been recognized by almost all the constitutions of all the countries, and particularly Ghana. Our constitution 1992, which is the supreme and fundamental law of the land, it provides as follows: Article 36, quote, "The state shall take appropriate measures needed to protect and safeguard the national environment for posterity, and shall seek cooperation with other states and bodies for purposes of protecting the wider international environment for mankind," unquote. Protection and enforcement of environmental matters are one of the economic objectives that Ghana seeks to achieve as it drives the wheels of the country to realize the protection of fundamental human rights, a healthy economy, and the right to work under safe and healthy conditions. The duties of the citizenry have also been enshrined in the Constitution of Ghana, 1992, for the establishment of a just and free state. It therefore imposes a duty on every citizen of Ghana to protect and safeguard the environment. The above two constitutional provisions, that is Article 35(2) and 36, which I've quoted not long ago, have put matters on environment on a higher pedestal above other matters, even though they are equally important. Some environmental matters, including the right to clean water and working under satisfactory conditions, were subsequently considered as fundamental human rights issues. The UN Human Rights Council Resolution A/HRC/RES/18/1, passed on 28 September 2011, made access to safe, sufficient, and affordable drinking water a basic fundamental human right. Economic rights with respect to employment and satisfactory working conditions is another fundamental human right applicable to all countries as a result of customary international law, that is the Universal Declaration of Human Rights, and Article 24 of the Constitution of Ghana, 1992. Even though we all know that the Universal Declaration of Human Rights is a soft law, it has been quoted with approval in almost all the jurisdictions in Africa, and have therefore been considered as customary international law within the specific jurisdictions. Africans should not continue to have issues with environment by the application of Universal Declaration of Human Rights, which is a soft law, but used by the African Court as part of customary international law. The African Charter on Human and People's Rights, known as the Banjul Charter, which has a binding effect on the signatory countries, also provides for a right to general satisfactory environment. A duty is imposed on every state to protect and preserve its environment for the living and posterity, but greed and selfishness have defeated the importance of environmental rule of law, particularly in Africa. Who are behind the greed and the selfishness and cannot be exposed? If they are not exposed, won't we continue to be preaching about environmental offenses, environmental crime, and remain where we are, or even becoming worse off? To ensure that environmental rule of law does not exist on paper, and we do not pay lip service to it, the perpetrators of environmental offenses and crime must be unmasked. We know them, so they must be unmasked. Environmental pollution in Africa has been on the ascendancy, despite efforts by persons in authority to prevent or curb the menace. The use of fresh air, which is to be enjoyed in its unadulterated state to keep mankind healthy, has been seriously polluted through the activities of the same mankind. It is not right to say that human beings, is it not right to say that human beings are their own enemies? We need air, we pollute it. Environmental degradation, we cause it. Marine pollution, we cause it. Are we not our own enemies? Air pollution affects every part of the continent, and therefore all the living creatures within the continent are breathing and inhaling polluted air. Most of the countries in Africa, and in particular Ghana, depend on the sea and other river bodies for their fish intake. The pollution of the sea affects the use of the sea, the fish, and mammals, which are used to feed mankind, and their domesticated and captive animals. Unregulated bushfires also pollute the environment and seriously affect river bodies, animals, and plants. Trees and plants do not have access to escape bushfires and are seriously suffered, forgetting that mankind depend on them for larger part of their meals. They are immobile, immobility of trees, immobility of water bodies. So when there's bushfire, they cannot run away, they are bent. Illegal felling of trees affects the environment and has damning effect on the ozone layer, whose importance to the survival of the living creatures on Mother Earth cannot be understated. Illegal mining and quarrying are presently the serious enemies to the environment in West Africa. Illegal mining and quarrying affect the land, rivers, water bodies, air, vegetation, and thereby exposing the people in the sub-region to all kinds of diseases, including but not limited to Bururi ulcer and glaucoma. Bururi ulcer is like leprosy affecting the whole body. And glaucoma, it affects the eye. If you become blind as a result of pollution, what will be the effects? The water bodies have been polluted and their beds destroyed, making it unfit for human and animal consumption. The average people in the sub-region have resorted to the use of boreholes without taking into account that the illegal chemicals and substances which are used by the illegal miners have polluted the underground water and making it unfit for human and animal use. A recent research by Duke University in the second largest town in Ghana, Kumasi, revealed that the underground water table has been polluted by the unregulated use of petroleum products by mechanics, accounting for the premature age of the people in the community. And when they die, people are talking about voodoo, that they are making quick money. That is why they are dying, which is a myth and interesting. Prosecution and initiation of environmental matters. There are good laws to control environmental offenses to ensure that flora and fauna enjoy healthy life, but these laws have become white elephants. Almost every country in the sub-region has an environmental protection agency or authority to curb the menace, but how effective are these laws? In Ghana, the environmental protection has been given the mandate by the Attorney General, which is responsible for the initiation and prosecution of criminal cases to prosecute some of the environmental offenses. Article 88 of the Ghana Constitution attests to that. The judiciary has created an environmental division of the High Court, and the district courts handle environmental matters, but there are no cases for them to handle, while thousands of environmental offenses and crimes are committed daily. It is not an open secret that illegal mining goes on in the forest reserve and some areas daily by the perpetrators, but are not arrested and dealt with, and they continue with their illegal activity to pollute the environment, to affect the whole mankind. Environmental matters affect the public at large and cannot be initiated by individuals in most common law countries, as they are normally brought by the state to abate public nuisance. It has been held by the Apex Court in Ghana in the case of Amidou Al-Hassan Amidou against another versus Mitiri Alawiye and 6 others, 2019 DLSC 6553, that it is the Attorney General which has the power to initiate action, civil suits in public nuisance and not private persons. While private persons are suffering, the law has made it impossible for private persons to assert their right to abate public nuisance, and it is vested in Attorney General, which is also the Minister for Justice. Government efforts to protect the environment. Ghana enacted the Maritime Pollution Act 2016, Act 932, to fight marine pollution from various angles, including prevention of marine pollution by dumping of waste and other matter into the sea, prevention of pollution by oil, prevention of pollution by noxious liquid substances in bulk, prevention of pollution by harmful substances carried by sea in package form, prevention of pollution by sewage from ships, prevention of pollution by garbage from ships, and prevention of air pollution from ships. The government have been equipping the Navy and the Air Force to enable them to patrol the sea and arrest offenders. Even in Ghana, ships were bought for the Navy purposely to fight, and aircrafts were bought for the Air Force to fight marine pollution. What is the result? And the Marine Police was also formed from the Ghana Police Service to help curb marine pollution. Have they made any meaningful strides in the fight? And it is negative. The government of Ghana, on assumption of office, determined to curb illegal mining, which is really a menace, and has set up a team of soldiers, police officers, immigration service, the national security, and the Bureau of National Investigation, co-named Operation Vanguard. Operation Vanguard at its initial stages seized over 500 excavators owned mainly by Chinese and few Ghanaians, which were used for illegal mining. The illegal mining is still going on, and some of the impounded vehicles have allegedly got missing. There are serious environmental issues in the sub-region, mainly marine, air, land, river, bodies, vegetation, and soil. That is all sorts of environmental issues pertain in Africa, pertain in Ghana. It is therefore impossible for the flora and fauna in the sub-region to have a healthy life from the polluted environment. Unmasking. Who are committing these crimes and are wearing the mask, the face masks? Who are wearing them? We have to know their face. We have to lift the veil. Who are they? The question is, who are behind this environmental pollution and environmental crimes? Firstly, governmental agencies responsible for fighting the menace have either acquiesced or benefited from the wrongdoing. Is the Mineral Commission aware of the upsurge in illegal mining and quarrying, that is the regulatory body? What steps have been taken to address the menace? Are the police officers and members of Operation Vanguard unaware of the menace and the areas where the illegal activities go on 24 hours a day? They live in the same environment, they breathe the same polluted air, they feed on the same polluted fish, and no efforts are being made to curb them. Secondly, the unemployed Chinese citizens come through the airports and land borders nearly daily and are given resident permits contrary to the laws of the countries in the sub-region. It is notoriously known that these Chinese come to undertake illegal mining and quarrying. And if you happen to visit any of the areas which have been occupied by these Chinese undertaking their illegal mining, they are fully armed. They carry weapons, armed. And if you're not lucky, they may even kill you. The Chinese bring...
Justice Ajay,
I'm winding up.
Yeah, thank you very much, and thank you.
The Chinese come through the airports, so now what do? We need political will to curb this menace. It is alleged that some politicians are behind this crime. It is alleged that some big people within the sub-region are behind this crime. So what do we do? The only thing we must do is that we must lift the veil. We must unmask them and prosecute. If we have effective courts, effective prosecutors, effective arresting officers, then I think the menace of pollution will, at no point in time, become a thing of the past. Thank you very much.
Thank you very much, Justice Ajay, for that captivating presentation. You have done a very good job in unmasking the perpetrators of environmental crimes in Africa. And your conclusion really summarizes the importance of your presentation, which is that if all the other stakeholders in the justice sector play their role effectively, then the courts will also efficiently curb environmental degradation or environmental crimes. So I really appreciate you for that presentation. And we do hope that we will have interesting questions which will emanate from that presentation. The second presentation will be made by Justice Dambuza, and the paper that Justice Dambuza is going to present is a realization of the right to a non-harmful environmental episodes from Africa judiciaries. Justice Dambuza, the floor is yours.
Thank you very much. Many greetings to colleagues and everybody that's tuned in. In this brief paper, I intend to review developments in environmental justice in a few countries in Southern Africa in the recent past. My focus will be on the smaller African region known as the Southern African Development Countries, the SADC. I have narrowed my area of focus to development in water law jurisprudence as a subclass of environmental law. And the reason I have done so is that my own little town called Butterworth has been without water for more than a year now. I explore whether and how judiciaries in this African sub-region have given content to the rights to environment that is not harmful to life in general and human life in particular. Now, some of the countries within the sub-Saharan region are particularly endowed with mineral resources. But on the other hand, it is widely acknowledged that the entire sub-Saharan region is particularly water deficient. Concerns about water risks continue to grow. Water availability and usage in one country sometimes has serious impact on its neighbors. South Africa shares 15 major rivers with other SADC countries. For example, the Orange River Basin traverses Lesotho, South Africa, Botswana, and Namibia. So now water becomes a strategic source that is critical for social and economic development in all of these countries at once. In this context, international agreements such as the UN Convention on Law of Non-Navigational Uses of International Water Courses become one of legal instruments that will hopefully play an important part in the regulation of the impact of the rapid increase in demand for water and the effect thereof on international water courses. Given the different countries and concomitant administrations in the countries traversed by these rivers within SADC, it is concerning that the right of access to water is entrenched in the constitutions of only 3 of the 15 SADC countries, those being South Africa, Zimbabwe, and the Democratic Republic of Congo. The Zimbabwean constitution protects the right to safe, clean, and potable water. The South African constitution grants everyone the right of access to sufficient food and water, and it imposes on the state a duty to take reasonable legislative and other measures within its means to achieve the progressive realization of these rights. And the Congolese constitution protects the right of access to drinking water. In other countries such as Namibia, the right to water is only provided for in national legislation. Now, the concern is this, that these rights when these rights are not given prominence in constitutions of the countries, their enforceability and justiciability might be compromised. There's even an argument that constitutionalizing this right to water in Southern Africa could lead to improvement in water security within the region. Apart from the constitutions of the different countries and the relevant national legislation, the SADC countries are signatories to a number of treaties in which the right to water is specifically provided for. So they therefore have a duty to honor these commitments under these agreements. For example, Chapter 16 of the African Charter on Human, People, and People's Rights provides for the right to highest attainable mental and physical health. So how have the judiciaries in this region then employed the tools or legal instruments at their disposal to give meaning to the right of access to water? And what is the ripple effect of the meanings that have been given, if any? In South Africa, the meaning of constitutional right of access to water was articulated in the Constitutional Court in the case of Mozambique and others versus the city of Johannesburg. In this case, the residents of the city of Johannesburg challenged the decision by the city of Johannesburg to supply 6 kiloliters of water to every account holder in the city, and the introduction of prepaid water meters, a policy which became known as the Free Basic Water Policy. Some residents challenged this policy as an affront to their constitutional right of access to sufficient water and their right to dignity and equality. The Constitutional Court, in interpreting Section 27(1)(b) of the Constitution, in which this right is articulated, highlighted the context facing the city of Johannesburg. It took into account its exponential growth, the large number of poor households, about half of them with income of less than $100 per month, with no sanitary services or tap water within 200 kilometers of their homes. The court took into account the need to improve the quality of life of all citizens, and all of this within this semi-dry context in which the country is located. The court emphasized that the government's responsibility is careful management and balancing of a scarce resource on one hand, and the realization of the constitutional promise to sufficient water on the other. And in the end, the court said the 6 kiloliter free basic water that the city was supplying to each account holder was reasonable. There has been criticism that the court should have engaged in its own assessment rather than what had been presented in front of it as evidence that supports the 6 kiloliter free basic water. In some of the SADC countries, where the right of access to water is not granted at all, but other basic rights are provided for, the bold steps taken by the courts in giving meaning to the internationally recognized right of access to water have been nothing short of remarkable. In Botswana, the case of the Basarwa people of the Seno region is a shining example of courts giving life-saving meaning to the right of access to water. The case is Masitlanyane versus the Attorney General of Botswana. Generations generations of this community had lived in the Central Kalahari Game Reserve. Initially, the government of Botswana had recognized their right to live on this land and had reserved land within the game reserve for protection of wildlife resources, with portions reserved for the traditional community settlements. But in 1986, the government changed the status of the Great Game Reserve to conservation status only. The people were urged to move to centers where services were provided. They came to depend on the mercies of cattle farmers who had drilled boreholes within the game reserve. Some of these boreholes were maintained by mining companies. But to make continued life in the game reserve impossible, the government came and sealed the boreholes. Although the communities were permitted to return to their ancestral land at some stage, they were not permitted to recommission these boreholes, even when they wanted to do so at their own expense. They approached the High Court, seeking an order that they be permitted to recommission the boreholes. Their application was refused, with the High Court holding that the government was under no obligation under the Water Act of that country to provide communities with water. But in a show of insight to giving true meaning to protection of socio-economic rights, the Court of Appeal in Botswana considered the act of sealing the boreholes to be a degrading act. It granted the community the relief they sought, and of significance to this discussion is the approach that the Court of Appeal took, relying on a right of occupiers of the land to harness water from the land. It ordered the reinstatement of water supply to the applicants on the basis that failure to do so would render nugatory their right to occupy the land, which the government had recognized. Equally, the Zambian High Court demonstrated similarly keen insight to the function of giving meaning to socio-economic rights in enfolding these rights of access to water where they are not specifically provided, enfolding them within the constitutionally protected right to life. In Nyasulu versus Kongola Copper Mines PLC, a mining company had discharged effluent into the stream, resulting in the stream water being highly acidic and seriously polluted, resulting in fish dying and people eating these dead fish. The rocks in the river were changing color as a result of oxides in the water. The court found that the mining company had been grossly negligent, and it also found that the mining company had been shielded from criminal prosecution by political connections and financial influence, which put it beyond the pale of criminal justice, just what our brother has been alluding to now. In this case as well, the court found that the right to water that is not harmful to human life is included in the constitutionally protected right to life. South Africa has also been plagued by waste management and pollution challenges emanating from the mining industry. Acid water drainage has been described as the most significant environmental problem facing the country. Anti-pollution measures where they have polluted were rooted in the Constitution, and it highlighted principles set out therein. It is clear, therefore, that the protection of environmental rights in the constitutions strengthen the justiciability of these rights. And it is also easier for people to recognize and seek enforcement of these rights in their own terms. But we also learn that even where there is no constitutional guarantee for these rights, that is not the end of the road. The extent to which judges draw from colleagues plays a big role in enriching their interpretive exercise. Awareness of diverse approaches to interpretation of legal instrument in giving meaning to environmental rights goes a long way towards realizing these rights. The recent formation of the African Judicial Education Network in Environmental Law, aimed at enhancing the capacity of judges in interpreting environmental laws, will broaden even more the judges' interpretational skills and accelerate the journey to protection of the environment for present and future generations. Thank you.
Thank you, Justice Dambuza, for respecting the time, and I really appreciate you for that very important presentation, which actually was brought a regional aspect to the presentation because you looked at the whole of SADC, and also highlighted the nexus between human rights and environment, a very important and topical issue that you discussed. And the cases, obviously, that you highlighted are very important for this particular presentation. And we do look forward to you sharing the presentation with everyone, just like the presentation of Sir Dennis Adjei. I'm sure it will be very helpful to everyone. The next presentation is a presentation by Dr. Millicent Odeni of the High Court of Kenya. And her presentation will focus on the recent legislative policy and judicial developments in environmental rule of law in Kenya. Justice Odeni, the floor is yours.
Thank you very much, Justice Emmanuel. Good morning, good evening, good afternoon to everyone. My presentation, as rightly stated, is on the recent legislative policy and judicial developments in environmental rule of law in Kenya. But I will largely dwell on the judicial developments in environmental rule of law in Kenya. So the presentation outline, I'll have a brief introduction, and then the recent legislative and policy developments, recent judicial developments, that is case law, and I'll deal with 3 notable cases, which I call plastic ban case. The second one is road network sanitary facilities or toilets case. The third one is on lead poisoning case, then a conclusion. I will start with the quotation of by Justice Antonio Benjamin, in a past webinar series, where he stated that we cannot protect the environment and nature without a strong presence of judges who are informed of the science behind environmental conservation. That we are the keepers of status quo, and it is hard for us to change. This is a wake-up call for judges to be forward-looking and ready to embrace the new normal in environmental conservation and application of the constitutional principles. When we look at the recent and legislative and policy developments, we know that environmental policy is anchored on the provisions of the Constitution, which guarantees every person in Kenya the right to clean and healthy environment. The 2010 Constitution of Kenya also recognizes the fundamental principles of environmental law, which include sustainable development, equity, protection of indigenous knowledge and genetic resources. States are also obliged to sustainably exploit the genetic resources. As we always pride ourselves as one of the countries in Africa or in the world which has a specialized court in environment and land. The Environment and Land Court was established via an act of parliament in 2011, which gives the Environment and Land Court original and appellate jurisdiction to handle environment and land matters. What it does not give the court is criminal jurisdiction to deal with environmental offenses. I will deal with issues of forestry and climate change on policy front. The Ministry of Environment and Policy and Forestry recently launched a national strategy for achieving and maintaining over 10% tree cover by 2022. The strategy is cross-sectoral framework that aims to address issues of acceleration of tree cover, impacts of climate change, and protection and conservation and management of forests. These are ambitious goals, but if implemented to the letter, then it would help in the conservation and of the environment and for the present and future generations. The impacts of climate change are real and has affected the world over in different proportions. Kenya ratified the Kyoto Protocol in 2005 and has shown commitment in contributing to the continental and regional climate change initiative for the benefit of the present and future generations. Further, the country's constitution has set out a legal commitment to attain ecologically sustainable development, hence providing a firm basis to address the challenge of climate change while striving to attain the development goals set out in Kenya Vision 2030. The response to climate change in Kenya must adhere to constitutional governance, framework, and commitment to sustainable development while addressing the goal of attaining low carbon climate resilience development. There are serious threats to the environment posed by lead and paints, to which the Kenya Bureau of Standards has developed and gazetted the East African standard to curb the production, importation, exportation, sale, whose lead content exceeds 90 parts per million. When we look at the recent judicial developments, it should be noted that the Environment and Land Court is not handling many environmental cases as was expected. This was stated by Justice Samson Okongo in April 2017 during a symposium in Auckland on environmental adjudication and in the 21st century. This was also confirmed by Justice Oscar Ngote in his thesis titled "The Role of the Environment and Land Court in Enforcement of Environmental Law" in 2018. We know that he came to the conclusion that despite the fewer environmental judgments emanating from the ELC, which is less than 1% of the total judgments, the Environment and Land Court has continued to develop environmental jurisprudence on issues such as rule of standing, that is locus standi, public participation in environmental matters, jurisdiction of ELC, and application of international law principles. If ELC is given more opportunities through environmental litigation, it will play a greater role in protecting the environment through judicial pronouncements. The judges cannot go out of their way to look for cases to pronounce this judicial, to have the cases heard. So there has to be something to be done so that people bring cases on environmental issues. So the recent notable environmental related cases, The Environment and Land Court has in the recent past been faced with complex legal issues in respect of the protection of the right to clean and healthy environment for the Kenyan citizens. There are 3 notable cases which were handled by our judges in the past 2 years, which have gained domestic, regional, and international attention. In the first case, which is Kenya Association of Manufacturers and 3 others versus Cabinet Secretary, Ministry of Environment and Natural Resources, the dispute emanated from the decision of Cabinet Secretary, Ministry of Environment and Natural Resources, and the National Environment Management Authority to ban the use, manufacture, and importation of certain types of plastic bags used for commercial and household packaging. The petitioners filed 3 separate suits, which were later consolidated. The central issue in the 3 consolidated suits revolved around the validity of the Gazette notice. The Gazette notice outlawed the use, manufacture, and importation of certain categories of plastic bags. The petitioners, being aggrieved by the ban, filed the suit seeking for various reliefs. The reliefs ranged from claiming that there was no public participation before the Gazette notice was issued, lack of statutory authority, violation of rights, orders of certiorari, and the prohibition of the implementation of the ban. The honorable judges formulated 10 issues arising from the pleadings and the evidence, and came to the conclusion that no rights had been violated. Therefore, the Gazette notice banning the use and importation of certain categories of plastic was in order and could not be impunged. The second case involved the petitioner. In this case, sought a declaration that the respondents had breached Article 42 of the Constitution and a prohibitory order to restrain the respondents, their agents, from charging any fee or obstructing citizens from accessing or using existing public sanitary or toilets, facilities or toilets. Further, he sought for an order of mandamus to direct the respondents to set up, operate hygienic sanitary facilities, including functional public toilets within their lawful jurisdictions and throughout Kenya's road network within 60 days. He stated that due to lack of options for proper sanitary facilities, motorists and commuters urinate, defecate, excrete human waste on the streets, road reserves adjacent to the bushes. The court ordered the Cabinet Secretary in charge of transport to constitute and chair the working group, which would include representatives of all respondents, to formulate the policy for provision of toilets and other sanitation facilities on the country's road network to give effect to the right to clean and healthy environment on the roads. The last case involves where the petitioner's claim against the respondents was that the 8th respondent leased a neighboring plot to the 7th respondent, which set up a lead acid batteries recycling factory, which activity produced toxic waste. That the waste seeped into the village, causing the petitioners and area residents various illnesses and ailments as direct consequence of lead poisoning, which with more than 20 deaths attributed to it. The petitioners claimed violation of several rights, which include right to life, right to a clean and healthy environment, right to the highest attainable standard of health, and right to a clean and safe water as guaranteed by Article 43(1)(a), D, Article 12 of the International Covenant on Economic, Social, and Cultural Rights, the CRC, the African Charter of Human and People's Rights, and also asked for general damages amongst other prayers. The court allowed the prayers in respect of the right to clean and healthy environment, right to life, and rights to the highest attainable standard of health, and right to clean and safe water. The court awarded Kenya shillings 1.3 billion as general damages to be paid. I'm done. I'm almost done within a period of 90 days. And the date of the judgment in default, the petitioners be at liberty to execute. These are forward-looking decisions which, if enforced to the letter, can help in the sustainable conservation of and management of the environment. Thank you.
Thank you very much, Justice Odedi, for that important presentation. And the presentation really gave us a history of the evolution of the legislative and the judicial and the jurisprudence of the environmental rule of law in Kenya. We really appreciate you for that presentation. The next presentation is from Justice Elisa Samwell, and it is, the title of the presentation is Strengthening Institutional Capacity of Judicial Training on Environmental Law in Africa. And the case study will be that of Mozambique Judicial Training Center. Justice Samwell, we do look forward to that presentation. The floor is yours.
Thank you very much, Justice Emmanuel. And also take this opportunity to say, well, I will speak in English because I didn't have time to prepare in Portuguese so that I can give to the translators. So I'm so sorry. And I'm also sorry because of my broken English, but I will try to do my best. I would like to say thank you to the World Commission on Environmental Law for this invitation. I'm very honored to be here with Justice Emmanuel. Happy to see you again. Last time it was here in Maputo, I think, in 2018. And also my friend, my mentor, Justice Antonio Benjamin, Justice Nambita also. We just saw together in Maputo in 2018. And my chief, my boss, Justice Sil Dennis, and also Dr. Milicenti from Kenya. Thank you all, and thank you also the Emily and all the team from WCEL for this invitation. Well, I will be very brief because I think my colleagues, they have stressed very well the trends, the recent developments on environmental law in Africa, so that I can focus on training. My presentation, it will be about judicial training, and doing so, I will talk about our case in Mozambique, our judicial training center, which in Portuguese, it's Centro de Formação Jurídica e Judiciária. But allow me to say that environmental sustainability is an unavoidable global principle which Mozambique embraced its importance in its legal framework. This is found in the fact that the country has developed and introduced the principle in its jurisdiction since the beginning of 90s. A set of legal instruments since then has been put in place, including laws, decrees, and other infra-legal norms applicable to environmental issues. The law of land, for example, was enacted in 1997. The environmental law also in the same year, and forest and wildlife in 1999 have been the focus of several state and non-state actors involved in this field. Let's say the judiciary itself, given the scope of conflict and acts of legal non-conformity that the new legislation would potentially generate. The historical context of the insertion of the environmental problem coincides with a notable boost to the country's economic growth and the discovery of natural resources at the national level, which has provoked a great demand for development projects with significant environmental impacts in our country. Nonetheless, the state's attention to this issue, the exploitation of natural resources in Mozambique, including energy, mineral resources, and practice linked to trafficking in animals and logging resources, threatening species extinctions, and the destruction of ecosystems have revealed cases of civil, administrative, and criminal liability, and that are factors that, among others, pose special challenges for the public, for the police, also for the judiciary as a system as a whole. With a view to protecting biodiversity and ensuring the sustainable use of these resources, and recognizing the importance of the environmental law and also the role of the judicial system in environmental protection, the Mozambican judicial system, through our Center for Legal Training, has established an agreement with UNEP, United Nations Environmental Program, to collaborate on integrating a program of environmental legislation in the training of magistrates, judges, and also prosecutors as vital actors in enforcing justice and environmental sustainability, as we heard my fellow colleagues here when they were presenting the topics. It was in this sense, actually, that in 2018, with the support of IUCN and also UNEP and other international and national partners, we did organize in Mozambique a Greening the Judiciary Symposium, where we gathered together more than 42 judicial training institutes from Africa, and also the judiciary represented around Africa, represented here with the Chief Justices in Maputo. And we also, in 2018, there was a Maputo Declaration, and one of the clauses of the Maputo Declaration, it was also strengthening the capacity building and introduce or revised our training manuals, the one that we use to train judges, prosecutors, and also lawyers in environmental rule of law. The project, as I said, is being implemented within our Judicial Training Institute. And now that we are speaking, we are about to organize a workshop a validation workshop to this manual. And I look forward also to, of course, to invite you all to be part of this workshop, which is going to be, because of the COVID, it's going to be also via webinar or e-learning or be-learning platforms. Let me please just stress a little bit about the structure of the curriculum that we are proposed in this elaboration. Well, the course is structured around the following topics, with a workload of 48 hours, namely foundation of environmental law, procedural aspects in adjudication of environmental disputes, and principal subjects, areas of environmental adjudication. Well, each topic comprises one module covering different subtopics, has a scope and content of environmental law, fundamental principles and concepts, and also a contemporary environmental matters in Mozambique, has climate change, environmental degradation like erosion, biodiversity loss, illegal fishing, let's say extractive mines and illegal trade in wildlife and forestry products, pollution, and also on module 2 about the procedural aspects in adjudication of environmental disputes. This topic will also cover a unit has like access to justice in on environmental matters, like public interest litigation, the issue of local standards, because we as a Judicial Training Institute, of course, we've been watching what the judges and prosecutors they've been doing within the courts. This local standard, it's in they do have some problems on interpreting how can they resolve this kind of environmental cases within the courts, and then therefore this is one of the topics that we use to train them in order to understand the trends in Africa and jurisprudence, and also globally, how they can also be used here within Mozambique. So public interest litigation also is been one of the focus in this new curriculum, and also the topic of the evidence in environmental cases. We will be focusing on the general matters on evidence in environmental cases, scientific evidence, how they can work with the experts in this area, economic and sociological analysis, also it's a part of the curriculum. Also the court and experts, witness experts, the standards and burden of proof, scientific and legal proof compared with other evidence that they can use. Also the remedies in environmental cases, and not less important, also the case management in environmental law, topics like good practice in case management, procedural speeds, visiting the sites and locality at issues, expert management, alternative dispute resolution mechanism. So this is a new trend in terms of curriculum design that we, with this project that we've been implemented with UNEP, we are using to, let's say, to improve our curriculum, because I did mention it. We before 2018, of course, our Judicial Training Institute used to train judges and prosecutors, also lawyers, on environmental rule of law, but it was more principles, also remedies. But now with this collaboration with UNEP, we are looking at these new trends because of the complexity of environmental problems, also environmental cases. We don't have a green branches as Kenya or South Africa. So the judges and prosecutors and also the police, they are the ones who used to work with, let's say, a common cases, and now they have to learn how to deal with these cases. Saying that, it's important also to notice that our public prosecutor office, they in 2019, I think, they create so-called a department to deal with environmental rule of law, and this department actually also conduct trainings, but more than trainings, it's been overseeing all the provinces, all the prosecutors, prosecutorial provinces, to see the uniformity, how do they investigate, how do they prosecute, and how of course courts do the trial these crimes. So I think it's important steps that they've been taken from our general prosecutor office, and it's been also improving the work within the judiciary, because as my sister from Kenya said, the judges cannot go out and look for the cases. So the prosecutors must bring the cases to the court. So as they're doing so, we can say that Mozambique is starting to developing a jurisprudence on environmental rule of law, which is good, because so that we can improve how the way that the courts are dealing with this kind of crimes. Just to come at the end, it's important also to notice that before 2014, we used to, let's say, the environmental crimes like wildlife, they were not having a criminal treatment because of the lack of the law. But since of 2014, with the approval of a law number, it's a penal code, the law of protection, conservation, and sustainable use of biological diversity, there has already been crimes against wildlife crimes. They've been prosecuted. That is also why the 2014 penal code has introduced also this type of crime. Today, with the into force of the law, the law that I've been talking about here, let's say we can say that the judiciary in Mozambique is improving, but of course we do have some challenges with training, continuous training, initial training, and also challenging in terms of sentencing process, because there is what the civil society normally says is that the penalties are not that the courts have been enacted. The penalties are very low, and doing so is not. It will be difficult to combat and to tackle this environmental crime. So, but with the new penal code, also the penalties, they've been revised, and the judges and the courts, they've been now being with a heavy hand, let's say, with their decision. So I will stop from here, and I thank you very much, and I'm sorry not to present in Portuguese because I didn't have time to prepare. I'm really sorry about that. Thank you very much. Back to you, Justice Emmanuel. Thank you.
Thank you very much, Judge Samwell, and I do believe that your English is as perfect as it can be. If that's your broken English, I wonder what your perfect English is, because it was very perfect. The presentation was very clear. And I really thank you, Judge Elisa, for the energy and passion that you bring to the area of training in the area of environmental law. And we thank you for sharing the curriculum that you've developed. I do believe that it's a curriculum which is worthwhile, and all of us have benefited from that presentation. So we are going to the question and answer section. Let me point out that don't feel offended if I don't recognize you. If I won't recognize the individuals who asked questions. I'm just going to pose questions directly to the panelists. Let's begin with Justice Ajay. There is a question posed to you, and the question is, to what extent can the Constitution contribute to balance between fundamental environmental rights and harm to environment? How do you strike a proper balance between protection of environment and development?
Thank you, my brother Emmanuel. When we talk about environment, there is a thin line between environmental issues and fundamental human rights issues. And at times, some of the environmental issues become fundamental human rights issues. For example, the right to clean and potable water. It was an environmental issue, but now it is a fundamental human rights issue. So my answer to the question is that there is a thin line between environmental issues and fundamental human rights. And it is just a matter of the state or UN taking it into consideration that this aspect of environmental law is so fundamental to the need of the people, and henceforth it should be considered as a fundamental human right. Now there is a correlation between environmental issues and development. Where you have poor environmental issues, no investor will decide to come invest in your country. So in a nutshell, what I would say is that there is a correlation in environmental issues vis-a-vis development. Where environmental issues are negative and poor, there will be poor investment because people will not be ready to come there to invest.
Thank you very much, Justice Ajay. The second question will go to Justice Dambuza. And the question is a bit broad. It's about the International Criminal Court prosecution, the ICC. Someone was asking whether you have a knowledge of whether crimes committed can be prosecuted in the ICC.
Is that environmental crimes?
Environmental crimes, yes.
Ooh, I really am not aware of that happening. I think the functions of the no, I'm really not sure. I think the definition of the crimes that can be taken to the ICC would be difficult to fit in, though, into environmental crimes, especially those committed within a particular state, except if maybe there's a large scale, something like the rhinos, because the parks flow into each other and there's a consistent and a persistent and high volume decimation or killing of, I really,
yes.
That's the best I can do. I'm sorry.
I think Justice Dambuza, that's a very fair answer to the question. I do believe that it's a broader question beyond this. We need more time to work on this topic, maybe for the next webinars. And there's a question, a very interesting question about the doctrine of public trust and public interest litigation. And the question is the doctrine growing in South Africa? And if so, how is it growing? And how is it positively impacting to the rule of to the environmental rule of law?
With regard to water specifically, the state is the trustee of water, and thus water cannot be privatized, or can only be privatized on certain very circumscribed, in very circumscribed circumstances, for example, where municipalities do really lack capacity, or where the provision is to private land, like these big estates. But the idea of public trust, or the state as a trustee of certain essential services, is definitely in place with regard to water. I am not aware of it having been tested and actually interpreted in courts as to how far it goes and what is exactly its meaning in a contested situation.
Yes. I think you are totally right that private interest litigation is an important component of the growth of the jurisprudence in South Africa. I believe even in the area of environment.
Yes.
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 Yes. And then another question which is very important, and I think which was posed to Justice Millicent. There was a question on the Save the Lamu case, which was decided in 2019. Do you have any elements as to whether it has been executed?
Justice Odeni, please.
Justice Odeni, did you hear our question? We cannot hear you. Yeah. Maybe when Justice Odeni is trying to resolve the technical problems, let's go to another question. And this is a very broad question to all the panelists. There was a question which was posed as to whether, and it's a question of cost. And the question is, cost is a factor that hinders many in approaching the courts on environmental matters. How do the courts in respective jurisdictions, represented by the panelists here, approach the issue of costs in environmental matters? We'll begin with Justice Samwell. How do the courts in Mozambique approach the question of costs when it comes to environmental cases?
Thank you, Justice Emmanuel. Well, I can say I'm out of the course like 4 years. I've been acting as a director, but of course I do have information. I do have information. Yeah, this is a very important question. Has in all generally the matters in in Africa, I don't know if other countries they do have like a free non-payment of the costs for the cases, but we don't have in Mozambique. So the cases must the costs are there. So we have to deal with the costs. In cases of environmental law, what I see is that normally the cases have been brought to the courts for a group of association, organization, NGOs, or the Mozambican Bar Association, and that is one of the impediment, let's say, to bring cases because of the experts and all the procedures involved in preparing cases, environmental law cases. But has any rule of law country, of course, this cannot be an impediment to bring cases to the court, and the public, let's say the prosecutors have the duty, constitutional duty, to protect the environment, and normally they are doing, let's say, the duties. They are bringing cases to the court, and it is not an impediment, a total impediment of the environmental cases to go to the court, and because of the cost. So I can say like this, Justice Emmanuel.
Thank you very much, Justice Samwell. A very informative answer to the question. Justice Dambuza, do you want to contribute to this question of costs in South Africa and whether it hinders environmental cases being brought to the court?
Yeah, of course, yes. Thank you, Manny. In respect of criminal prosecutions, one would, of course, not have to worry about costs because you go to the relevant authority and report an environmental crime, and there's no real cost implication because the state will prosecute on your behalf. But in relation to enforcement of rights, environmental rights, this is where the protection of environmental rights in the Constitution becomes important, because the courts, the Constitutional Court, in a case called BioWatch, ruled that any litigation by private individuals to enforce their constitutional rights against the state, costs will not be awarded against you, even when you fail. So this has a very big impact in that even if ordinarily a lawyer would have wanted money for you to assist you in enforcing your environmental right, the fact that you will get costs if you win, and therefore they can recoup their expenses, has made constitutional litigation very attractive. If you lose, then everybody doesn't gain anything, but you don't have to pay the other party's costs. And that works well because environmental rights are protected under the Constitution. And this is how a facet of importance of the protection under constitutional rights is important. So one doesn't really have to worry about costs. And there's quite a number of NGOs that are always ready to assist in these matters. It is becoming quite a widely interesting an area of wide interest. You know, in the beginning, people would look at environmental law and enforcement of environmental rights as some exotic area of law that really doesn't affect people in the streets. And one of the things that have raised the levels of alertness is the problems that we have with water in the country, and people, when they see that they can go for days without water, then it becomes a reality. Thank you, Manny.
Oh, thank you very much, Justice Dambuza. That's a very appropriate question. I think from our country, borrowed from the case law of South Africa on awarding costs against a party which loses if it's a public interest litigation. We said that you cannot penalize public-spirited individuals who want to bring cases against environmental degradation. So I think this has helped quite a lot in ensuring that more cases of this nature do come to the court. Justice Odeni, I want to ask you a different question, Justice Odeni. Do you think the introduction of specialized land and environment court in Kenya has added any value to the resolution of disputes in the area of environmental rule of law? I'm not quite sure that we can. And again, when we are trying to resolve this technical issue from Millicent's side.
Can you hear me now?
Yes, we can. Perfect. Please go
Okay.
ahead. Yes. Yeah.
Yeah, the introduction of the specialized court has given the court a dedicated time to deal with the environment and land cases. Because if previously all the matters were being dealt with by the High Court, and currently the Environment and Land Court has about 31 judges who specifically deal with cases on environment and land. And we find that it gives the judges more time to concentrate on these specialized issues dealing with the land and environment. But as I had stated earlier, we mostly deal with land matters and very few environment-related cases. I think it has increased in access to justice to the Kenyan citizens. And if we are given more judges, I think we'll be able to deliver to the citizenry. Thank you.
Thank you, Justice Odeni. There was a question which was earlier posed on the status of the implementation of the Lamu call case.
Yes,
about that.
I had stated that the last time I heard of it was when the court, the tribunal ordered that a fresh EIA be done. I have not followed it up again, so I might not be able to give the correct position.
Yes.
Thank you.
Thank you very much. I think it was a landmark decision by the judiciary in Kenya. And
yes,
we might be able to know the answer later.
Yes.
Justice Samwell, there was a question that was earlier posed. You talked about the training of judges and the prosecutors in Mozambique. Do you have any program of training of the journalists who report these cases? Because someone considers the journalists to be a very important aspect of what we do in the courts, especially that we want them to report our decisions accurately. Do you have any trainings for journalists?
Well, thank you. We don't train. Let's say our duties is to train all the judicial officials, but from judges, prosecutors, and legal aid, registrars, all of them. But of course, we organize a short courses with other stakeholders like NGOs, police, and also journalists, but not specifically on environmental issues, but in topic like in human rights topics in general. We didn't, as I recalled, we didn't yet organize specifically on environmental issues. I'm afraid, but I think it's a good idea. Well, but also they've been trained. They do organize, because we do have a MISA. Southern, I think it's Southern Africa media organization in Mozambique. They normally conduct trainings, workshops, conference with different topics, specifically in freedom of speech in terms of in human rights and everything. But we has a judicial training center. We didn't yet. We didn't train them yet. But it's a takeaway that we can work on it. Justice Emmanuel, thank you.
Thank you very much for that answer. I don't know whether Justice Ajay has an answer to this question, because you also do run the training institute in Ghana.
Thank you, my brother. When it comes to training, we train judges, prosecutors, and journalists with respect to environment. We train them as to do effective reportage. It is about reporting and not letting them know the law itself, but how they should report environmental cases, including both civil and criminal. Then the issue of cost, let me say something about it. Issue of cost. In Ghana, where it is a criminal offense, as we know, it is free of charge. And we have specialized court, 10 specialized courts. We have the environmental court, then we have court of general jurisdiction. The environmental court is in the capital, but in every region, we have 16 regions. In every region, you will get a court with general jurisdiction that will entertain environmental matters. And the district court, every district court in the country has jurisdiction to entertain environmental matter. Now, when it comes to cost, it depends who is bringing the action. If it is a class action and it is being brought, normally the filing fee is paid, but no cost is awarded at the end of the trial. But where an individual brings an action for damages, then if the person loses, cost is awarded against the person. But where it is brought by the Attorney General as a way to abate public nuisance, no fees is paid. So it depends on the person bringing the action and the interest the person is seeking. But where the person goes to the Supreme Court, the apex court, to enforce an environmental right created by the Constitution, then in that sense, just filing fee is paid and no cost is awarded. Then let me say one thing about this. Somebody asked about whether environmental offenses are triable by the ICC. No, the Rome statutes provide for only 15 offenses, and those offenses are offenses against humanities. That's the serious offenses: disappearance, enslavement, murder, rape. It does not include environmental crimes. Thank you.
Thank you, Justice Sir Ajay. I'm going to pose a very general question to all of you to answer from the perspective of your own judiciaries. And the question is, there are certain rights which are extremely important to the resolution of environmental cases. These rights are the right to information, the right to public participation, and and access to justice generally. How are these rights treated in your own courts in order to ensure that cases are effectively prosecuted in your courts? I'll start with you, Justice Dambuza.
Can you say those rights again, Manny, please?
The right to information.
The
right to information, because in order for you to be able to even bring a case before the court, you need to have all the information that involves that court, and then the right to public participation, and then finally the access to justice. How do courts ensure that these rights are respected when it comes to environmental cases?
The right to information is specifically legislated for. If you need information on in preparation for a public interest case, it's called the Access to Justice, Access to Information Act. All public institutions have to have an officer who is specifically designated as the furnisher of this information where it is needed. If you intend to institute an environmental rights enforcement case against a specific institution, whether it's a public or private institution, you can make use of that that act. It's got an infrastructure in place because it's used for anything and everything. So you get the forms and you say, this is the information I need, and you just serve it on the information officer of the institution. All the information that you need in respect of that is obtainable in that regard. If you are not satisfied, then you can approach court and say, compel these people to furnish the information. Public participation, it depends on the extent of your interest, I would say. If your interest is close enough to the matter at hand, then you can be joined one way or the other, or you can ask the court to be joined as an amicus. It is also a legislated process in terms of which you approach court and say, I can assist court in this litigation. I am applying to be admitted to the case as an amicus curiae to assist court because I have either information that I realize is not before court, or I can make some submissions by virtue of my expertise in the area. Those applications are normally granted as a matter of routine, and they have been, a lot of them have been made during our corruption cases, and there has been a lot of organizations and private people seeking to be admitted to cases as amicus curiae. Access to justice, yeah, that's quite broad, Emmanuel. I don't know where to start.
I think you had even answered it before when you talked about public interest litigation, that
okay,
anyone
all
can
right.
bring cases on the basis, environmental cases on the basis of public interest litigation.
Yes.
Thus, it grants a broad
yes.
justice here when it comes to environment. So you had already answered that. Don't worry about that.
Sure. So you're letting me off?
Yes, I am. Justice Adjei, the right to information and public participation, how is it treated before the courts?
Initially, we were using the civil procedure rules to ask for further and better particulars to build cases. But now we have the Right to Information Act, and the Secretariat has been set up. So now it's just a matter of writing into the person to provide. If the person fails, then you make a case to the Right to Information Secretariat, and they will ensure that the required information is given to you. Now, when we talk about right to justice, everybody who has an interest in a matter has a right to access to justice. But when it comes to Supreme Court, the apex court, when it is for constitutional interpretation or for enforcement of fundamental human rights, which is of public interest, you don't need to establish any capacity. That one, everybody, every Ghanaian has a right to go to Supreme Court to call upon the court to enforce fundamental human rights, which is of national or public interest, or where it is about constitutional interpretation. Then we talk about right to participation. Any person at all with knowledge in an area may file an amicus curiae submissions, and the court will entertain. But the only issue is that if you are filing for amicus curiae, then you should not be an interested party. You should be a neutral person, because you don't have any interest. That is why you want to be a friend of the court. And that one, you have free access to file an amicus curiae brief or submission. Thank you.
Justice Odeni, do you want to make any contributions to this particular general question?
I'd like to make a contribution on the issue of public participation. That is a very important segment whereby currently we have so many cases in our courts challenging laws or even policies which were passed without public participation. But public participation is guaranteed in the Constitution, and it is a must. You must go through public participation before you come up with any policy or any law or any gazette notice. So if it is not done, then the same can be considered unconstitutional or null and void. I've just seen some issue that someone raised, which I just want to answer quickly. I did not answer it because of time. There's someone who has asked a question whether there were any remedies.
Yes, I was going to ask that question. Yeah.
Oh,
Yeah.
okay, let me just finish with it
Please
now.
go ahead. Yes. Yeah. Mm.
Yes. The court further directed the named liable respondents to clean up the soil, water, and remove any waste deposited within the settlement by the 7th respondent within 4 months. That is 120 days from the date of the judgment. Thank you.
Thank you, Judge Odedi, for completing that question. And it was a very important question to answer. I really apologize that I cut you short of your presentation, but I think that's the only part
the only part that was remaining.
Yes, yes, and it's good that someone asked that question.
Yes.
Judge Samwell, do you want to contribute to this? And is it part of the curriculum that you teach on these other important rights which are important to the resolution of environmental cases, the right to information and public participation?
Yes, Justice. Yes, it's a part of our training curriculum. The module is human rights and citizenship. So we've been training judges, prosecutors for initial and continuous training. But it's very important, this question, because nowadays, we know our countries, especially Mozambique or other Portuguese-speaking countries, we normally talk about the infant democracy. Yeah, we do have our democratic constitutions where the rights are granted, the right to information and public participation as well. But in practice, there is a long way to go yet. In Mozambique, I would like to share an experience about the right to information and public participation. Our constitution, of course, granted the right to information. Because of that, in 2014, it was enacted. The right to information law is in place, but the law stress also that exercise of these rights must respect certain principles. One of the principles is the respect for the classified information. So in practice is that when lawyers or NGOs in strategic litigation causes which have to deal with mega projects or mining companies, that they're putting they violate the rights of the community, local communities. Normally when they ask for information, for whether it's private or also the executive, they use this article to deny the information. So there is a case within the court now that we are talking, challenging the right to information in terms of the mining companies, and also the government have to give this information. And unfortunately, the public prosecutor, in the first instance, I think they give rights, the judges, the route in favor of the community and also of the let's say these lawyers. But then, of course, there was an appeal. Sadly, it was the public prosecutor who appealed from against that decision. So now we are waiting to see what the court will decide. And there is also one case that it was decided in 2017, I think, about also local community rights. There were this public interest litigation case that was brought to the court, and has our constitution also stressed about public participation, but the law that deals with the public participation procedures, it is not yet been there's no regulation for the exercise of this, let's say, ação popular in Portuguese, as you said. So the court in the first instance says that the government have not yet regulated these public participation procedures, so that I cannot grant you this right. And there was, of course, an appeal, and fortunately and happily, the Supreme Court ruled that the fact that the Constitution is granting public participation, this is a fundamental right, so that the courts must respect, and they must hear the case. So this is a positive step, and I'm saying that because this decision was made for judges that they've been training in our Judicial Training Institute, and they are really improved in the way they are hearing the cases, and they said that they are deciding the cases. But we still have a long way to go in terms of right to information, and also to grant the public participation within the courts, and also within the executive and also private sector. Thank you.
Thank you very much, Judge Samwell. And I may actually, when concluding this exciting webinar, say that I will conclude with the words of Justice Samwell. Yes, we do have a long way to go. But again, a lot has been done from the presentations from the four panelists. I firmly do, you really made Africa very proud, you judges, from the presentations, but also from what you do. I firmly do believe that this generation of judges, with all its energy, questioning, new perspective, is well placed to positively contribute to the growth of the jurisprudence in the area of environmental rule of law. I do hope as participants that we have all derived from each other such benefits as we may offer to each other in as far as the development of our own jurisprudence in the area of environmental rule of law is concerned. I do also believe that we have common vested interests in each other's success, and initiatives such as this webinar help us all to make a contribution to that success. This webinar, which is an initiative of WCEL, has really provided a forum for all of us to cooperate, collaborate, and have constructive debate and effective interchange of views about what we do in our own judiciaries and what we can learn from each other. I am very confident from the presentations that we have individually and collectively come away with very valuable lessons. I really do thank you, panelists, and I do now take this opportunity to invite Professor Denise Antolini to make the closing remarks. But once again, thank you very much, panelists. I couldn't have asked for a better panel.
Thank you, Mr. Moderator.
And I would like to ask my dear friend and colleague, Justice Antonio Benjamin, if he would like to make a few remarks before I close. Antonio.
Thank you, Denise. I would like to thank everyone. And I will switch to Portuguese. Bem, eu queria agradecer a todos os palestrantes, em especial ao presidente deste painel e também aos colegas, aos 4 colegas que em tão pouco tempo fizeram um panorama geral do direito ambiental na África. Queria também agradecer aos participantes que apresentaram tantas perguntas interessantes, perguntas que são cruciais, por exemplo, sobre os custos nas ações coletivas, Public Interest Litigation. Evidentemente, esse é um dos problemas mais sérios e aqui o processo civil tradicional tem que reconhecer que os autores das ações ambientais prestam um serviço público. Então, a rigor, eles deveriam ser remunerados por estarem fazendo aquilo que deveria ser papel do Estado e, no entanto, é realizado por cidadãos que são extremamente dedicados. E o mínimo que as normas de processo civil podem fazer é dar isenção de custas a esses autores e só permitir a sua condenação em custas e honorários, attorney fees, quando agirem de má fé, bad faith. Este é o sistema brasileiro. Então, as ONGs, NGOs, podem entrar com suas ações civis públicas, public interest suits, sem a preocupação de, ao final, se perderem, receberem ainda uma condenação financeira que pode inviabilizar a sua própria existência como entidade da sociedade civil. Também aqui foram tratados aspectos de direito constitucional, se a proteção na Constituição precisa da mediação ou da intermediação de normas infraconstitucionais. Isso é muito importante para nós juízes e é muito importante também para o Estado de direito ambiental. Nós acreditamos que as constituições são o documento mais importante de cada país. E se assim é, essas normas, muitas vezes extremamente claras na proteção do meio ambiente, não precisam de normas legisladas complementares para a sua aplicação. É o oposto. É o poder legislativo que tem que se submeter às normas constitucionais e não as normas constitucionais ficarem na dependência, às vezes eterna, de manifestações do poder legislativo para simplesmente repetir o que já está no próprio texto constitucional. Vejo que outras perguntas que nem houve tempo para serem analisadas, como, por exemplo, sobre a doutrina do Public Trust, e que a África do Sul adotou na sua própria Constituição, e, evidentemente, são temas que merecem, cada um deles, um novo seminário. E as ideias ficam aqui. Não é? A pergunta sobre a Public Trust Doctrine foi feita por um participante de Sri Lanka. E é interessante notar que esta é uma doutrina tão importante para os países de common law e também para os países de regime misto, como é o caso de Sri Lanka, mas não tem muita relevância nos países de civil law. Então, são tantas as questões interessantes que ficam aqui para um próximo debate, e eu agradeço de novo a todos os participantes que nos assistiram e também aos palestrantes, e muito especialmente a professora Denise Antolini, que acordou de madrugada para coordenar este evento que eu reputo extraordinário. É o primeiro evento que nós realizamos, a comunidade dos juízes, para debater em webinário, numa região importantíssima como a África, esta temática ambiental. E que, portanto, seja o primeiro webinário de uma série que nós possamos realizar, especialmente com juízes, em capacitação dos juízes por meio deste formato que a pandemia nos obrigou a utilizar e que acho que agora fica, porque nós vimos que é possível fazer formação, diálogo por meio de webinário. Então, agradeço a todas e a todos e até a próxima. Professora Denise Antolini.
Thank you, Antonio. You said it all. And I just want to again acknowledge our partners, the Global Judicial Institute on the Environment, the United Nations Environment Program, and of course the IUCN as a whole. In closing, I just want to emphasize what Justice Antonio Benjamin just mentioned about some of the amazing questions and to really highlight here that you had a global audience for this webinar. We had participants not only from Sri Lanka, but Fiji, Canada, Turkey, and of course across Africa, which is all to say that the eyes of the world are watching what you're doing. And we're so inspired by the presentations today, and we look forward to more conversations, more collaboration. We really appreciate everyone's time and contribution. Thank you to everyone today, and we wish you a wonderful weekend. And from Hawaii, aloha to everyone. Goodbye. Thank you so much.
Aloha.
Aloha, Denise. Thank
Aloha.
you.